My name is Russell Berger. I'm the chair of the Labor and Employment Group at Offit Kurman. I help business owners solve their problems, particularly with respect to employment matters. Oftentimes, business owners think of employment law and human resources practice as a necessary evil. Now, it's not seen as a revenue center, it's not seen as something that furthers your goal as a company, but it's seen as something you have to do to avoid the problems that come up with bad employment practices. While by and large there's some truth to that, the reality is that there's things that you can use employment laws for that can actually protect you and help you grow the value of your business. So one particular area where that's true is with respect to confidentiality provisions. You work hard, you develop product, you have proprietary information, you have even intellectual property. You don't want your employees taking that information, going to a competitor, starting a competitor, putting it out there on the street for people to hear about. So it's very important that if you have that sort of information or you have employees who have access to that type of information, that you protect it. And so what we can do is put together a confidentiality agreement or a non-disclosure agreement that protects your confidential proprietary information. Along those same lines, we can do the same thing with intellectual property. So if you're developing a product, whether it be something tangible or software or a process or a methodology, that's something that you can protect, and it's really important that you do, because if you've got some bright people working for you and they're innovative and they're coming up with new things on your dime in your shop, you want to be the party that reaps the benefit of that, and you don't want your employees to be able to take advantage of you in that way. And another way where protecting yourself becomes very important is with respect to your customers as well as your employees. In the law, there are non-compete agreements and there are non-solicitation agreements, and they should be carefully crafted to your specific situation, but they're a very good tool for protecting your clients and your employees, as well as to some extent the environment in which you operate. To my mind, it's most important that you protect your clients. So you've worked hard, you've grown a book of clients, maybe even have salespeople or other people on your team that you work closely with who have contact with those clients. You want to make sure that if they leave your employment, they can't take those clients with them. And it's really important that you get protections for that, because you could do all these things right, you could build your business, you could be hugely successful, and one good salesperson could take your biggest client and now you're operating at a loss. So you want to make sure you protect one of your biggest assets, which is your book of business. Similarly, you can do the same things with your employees. You don't want someone to leave and take a team with them. So there's what's called anti-rating provisions that protect or prevent employees from leaving and taking your team or members of your staff with them. One area where I find that business owners run into a lot of trouble is with respect to wage and hour compliance and the Fair Labor Standards Act. That's the law that requires businesses to pay their employees the minimum wage and an overtime premium for hours worked in excess of 40 hours in a week. Now, there's a lot of different ways business owners make mistakes in this area. I tend to summarize them and put them into three different categories. The first category is misclassification. That's where an employer calls an employee exempt, meaning that you're not entitled to overtime pay when they actually are non-exempt and are entitled to overtime pay. And the problem with that is once you misclassify someone as exempt, then you don't do the other things that you're supposed to in order to ensure compliance. The second area where business owners make mistakes with respect to overtime pay is in tracking hours. And oftentimes business owners don't know what it means to actually be an hour of work, or breaks will be too short, or certain time will be excluded or not captured, or there's a bad time recording system. Those are problematic because you're missing hours that need to be paid. Third large category of mistakes business owners make with respect to overtime pay is in calculation. Oftentimes business owners rely on their payroll system to calculate overtime pay, and that's not a good practice because business owners need to be calculating on their own, because frankly the payroll systems don't cover proper calculations. Instead, what business owners should do is make sure that they're incorporating all compensation and paying an overtime premium on all compensation that qualifies for what the law calls the regular rate. Another area where business owners tend to run into trouble is with respect to classifying someone working for them as either an employee or an independent contractor. Now, oftentimes, business owners will say, well, I pay them a 1099, so they're an independent contractor, right? Of course, that's not the legal test. The legal test depends not just on how a business owner classifies the worker, but what the worker is actually doing and the amount of control the business owner is exerting over that worker. So while it's nice to think, hey, I can just classify this person as an independent contractor and then I don't have to pay payroll tax or workers' compensation benefits and I don't have to worry about overtime premium, it's not that easy for a business owner. Instead, all these different laws where classification matters have their own tests for determining whether someone is an employee or an independent contractor. And while the details of those tests can be very fact specific, the main point here is that the amount of control exerted by the business owner over the worker is going to be a key factor in determining whether someone's an employee or an independent contractor. The main take-home point for the business owner is to know that you can't just make someone an independent contractor because that's what you want, and you should really consult with counsel or do some research and get some guidance as to what the proper classification should be. Oftentimes, we find that businesses do complete performance reviews of their employees, and they'll make a big deal of performance reviews. It'll be an annual process, and especially at companies where somebody who's not the owner is completing the performance review, the problem that we find is that they're not taken very seriously. There's few things worse in the employment context than just creating ineffectual documentation. You've spent all this time creating your performance review form, you've developed the process for performance reviews, you go to roll them out, you train your managers, you train your staff on completing them, and then they don't take it seriously and you don't get a good product in return. And that's problematic because one, you've wasted a lot of time and effort in this process that yielded no return, and two, it creates the wrong impression for your employee. Your employee thinks they're performing adequately or slightly above average because the person completing the review didn't take it seriously, when in reality, they're struggling, or maybe they're a high achiever, but they're struggling in one particular area. So your challenge as the business owner is to make sure not only that you do performance reviews because they're valuable in a lot of contexts as an employer, but that when you do them, you make sure they're done accurately and thoroughly. When you go to lunch with someone and you're eating your lunch with a business contact, an important referral source, sometimes, like anybody, they might get something stuck in their teeth. You're sitting across the table from that person and you see this thing stuck in their teeth. You want to say something about it, but you don't want to make them feel bad, you don't want to make them feel uncomfortable, you don't want to be seen as the person that's giving them a hard time. But if you're anything like me, I want to be told when I have something in my teeth, and I want to be coached when I'm doing something wrong. In the employment context, a lot of employers are afraid to have that type of conversation, and that only makes things worse. Now that person who's got something stuck in their teeth is going around their entire afternoon with something stuck in their teeth, embarrassing themselves in front of everybody they know or everybody they run into that day. And it's the same thing in the employment context. If someone's making a mistake, they need to be coached on it because the mistake isn't going to fix itself. They need coaching, they need guidance, and it's incumbent upon you as the manager or the business owner to give them that coaching and get them pointed in the right direction. If you don't take any action, if you don't take any steps, you're just going to run into the same problems over and over again, and you're going to have someone who's capable of being a good performer but who isn't meeting your expectations. And that tough conversation, although it is tough and it's unpleasant and no one really wants to do it, is what sets good managers and good leaders apart. What often happens with businesses is they start out and it's a very small shop, and it's the business owner and a couple people he or she knows. And at that point, while I'm always going to say you should have formal employment practices, they're not nearly as critical when you've got 3 or 4 people on the team and they all know each other. What I've found over the years is that when a business starts to get to 10 to 15 employees start getting hired who the business owner doesn't know, who's not part of that intimate original nucleus. And when that happens, you're at a lot more risk for employment disputes brought by these employees. Not to mention the fact that as you grow in numbers, new laws apply to you, and you're going to have to formalize some processes anyway. But when you get to that 10 to 15 employee critical mass, I think it's really important that you, if you don't already have one, get an employee handbook in place. And the employee handbook is a place to set forth your policies, set forth your practices, make sure everyone's on the same page as to how to operate in certain situations. There's probably not that many employees that are going to sit there and read a 30, 40-page employee handbook that they get at orientation. But it's really important for you because they'll use it as a reference guide, and you can use it as a reference guide. And not to mention the fact that you can carefully craft your employee handbook to have all the right policies that say all the right things that are entirely consistent with the law. And then if you ever get into a dispute about a specific employment practice, you've got Exhibit A right there that says, hey, here's how we do things, and it's lawful. In my practice as a labor and employment attorney, I often get phone calls from clients where they ask, am I okay to fire this person? Or, what's my risk if I let this person go? That's a hard question for me to answer as the attorney, but, the place I often start is, okay, well, send me their personnel files, send me their documents. I'll take a look at it and I'll give you an assessment of that. Often what I get back from the client is a generic personnel file where it's got the employment application, it's got some payroll history, and it's got performance reviews where the scores are average or slightly above average, and there's no real detail to it. The problem that then creates is that the employer hasn't created the record to support termination. Now in Maryland, most everyone who's an employee is at will, which means they can be terminated at any time for any reason as long as it's not an unlawful reason. The risk you're trying to prevent or guard against as an employer is the risk that someone claims that they were terminated for one of those unlawful reasons, whether it be discrimination or retaliation or something else. And the best way to do that is to be able to explain and show and demonstrate to a judge or to a jury why that person was terminated. And when you don't have the documents, you haven't built your case, that can create a problem. The best practice is to document performance issues as they arise through clear, simple, objective documentation. It doesn't have to be anything too detailed. It doesn't have to be necessarily written by a lawyer, although in some cases maybe that's appropriate, but just documentation that's contemporaneous so it doesn't look like at the end of the day you just didn't like someone, or worse yet, you didn't like them for some unlawful reason and you terminated them. If you get that allegation, you want to be able to say, no, we terminated this person because they were a poor performer, and here's my documentation, here's my proof. One of the particular challenges with respect to employment law is that every jurisdiction can have its own employment law. So while the federal government sets basic employment standards, such as the minimum wage, states and local jurisdictions can enact more onerous restrictions. So for example, with respect to minimum wage, the federal government sets a minimum wage. The state of Maryland has a higher minimum wage than the federal government. So for anybody working in Maryland, the minimum wage is higher. Then local jurisdictions can have even higher minimum wages. And that's not only true for minimum wage, but it could be anything. There are different employment laws that apply in certain counties in the state of Maryland, let alone the state of Maryland, that might not apply out of state. And if you have a business where you have employees in multiple states, let alone multiple counties or multiple cities, you could be subject to a lot of different requirements. A lot of them are pretty similar, but the differences are enough that it makes sense to understand what they are, to pay attention to them, because they could be something that could trip you up, and you don't want to find yourself in a predicament where you comply with the federal law, but you didn't comply with the law in Maryland. One area that isn't necessarily an employment practice, but it's an employment-related idea, is what's called employment practices liability insurance, which is often referred to as EPLI. Now, employment practice liability insurance will cover a lot of claims that an employee could bring against an employer. It's not necessarily the most cost-effective insurance product out there, but what it really is a catastrophic harm insurance. So if someone leaves and they're suing you over $10,000 or $15,000 because it took them 3 months to find their next job and they're claiming they were discriminated against, EPLI isn't necessarily going to help you all that much in that situation. But if someone's earning $100,000 a year, $200,000 a year, and they're out of work for a year, you're going to be really happy that you have insurance coverage for that type of claim. One caveat to EPLI is there are insurance products out there that cover wage claims, but they're few and far between, they're very expensive, and oftentimes they don't cover the unpaid wage itself. They'll cover defense costs or statutory damages associated with the wage claims. That it's really important that you make sure your pay practices are appropriate and lawful, because that's something where it's even harder to get insurance coverage. I think one of the things that's critical, not only to business owners, but to any professional, is that you understand what you're good at and where you're weak. And understanding your strengths and your weaknesses, I think, is a critical part of being successful at anything. Sometimes you have people come in and they'll say, hey, you're weak at this, you really need to improve at this area. I think it's nice if you can improve at that area, but I don't think you're all that likely if you're an A performer at 80% of what you do and you're an F performer at 20% of what you do. I don't think you're going to go from an F to an A. I think you might go from an F to a D or an F to a C. So what I think is really important is understanding those areas where you're deficient and surrounding yourself with people that complement you. You don't want a carbon copy of yourself, because then your company is still going to be weak in that same area. If you're a risk-taking marketing genius, then you probably should hire a chief operating officer to balance you out. And if you're analytical and you like burying your nose in a spreadsheet, then maybe you need a good marketing team around you. Whatever it is, I think it's really important that you understand where you're strong so that you can hire to balance that out. And along those lines, I think it's also important that where you don't know things, you ask questions, or you surround yourself with a team of people who are able to bring those issues to your attention. With respect to employment law, for example, there's different employment laws in every county, in every state, in every country. If you're an entrepreneur, you're not going to know those laws. You need somebody like me to make you aware of where your risks are and what you should be paying more attention to. And you probably need the same thing with finance or with marketing or with the operational components of your business. And I think it's really important that you do what you're good at and you get help where you need the help.